September 9th, 2022, First Amendment auditor Joshua Roberts, who's the owner of the Pepperoni Audits YouTube channel, was filming outside of Dove Technologies in Florence, South Carolina, when two workers left the building and approached him as he continued to film.
You don't have my permission, you can turn that off right now. Have my face on there.
What was that? I can't hear you.
You don't have my signed authorization to have my face on that camera. Turn it off.
Can I have your signed authorization? This guy's coming up aggressive, everyone. Can I help you?
No, can you help us?
Yo, get away from me, buddy.
No, dude. Who are you?
Away from me, dude.
Why are you here?
Back the
Why are you here?
I suggest you leave me alone.
You're on private property.
I suggest you do something about that then and get back inside.
Ooh. Really?
Yeah, really. You like going around with people like this?
You know
think
what?
That's fun? Don't touch my buddy.
Oh, go ahead. Oh, so
do it. Do it.
What?
Touch shit. That's on camera.
What
back the.
What are we doing here?
Back the off, buddy. You touch. You get tased. Get the back inside.
What's going on here?
Why did you come up and grab me?
You back off.
Yeah, you did. Yeah, you did, buddy.
Get that thing out of my face.
No, you come up to me, get in my face, I'll do something, buddy. Get inside.
I'll call 911.
Get inside.
Call the sheriff's department. Yep. Whoa, dude.
Whoa, dude, you just come up and grab people? The is wrong with you? Your homie did.
Don't hate my homie. This is private property. You say you're filming.
This is an easement. I'm not on your property. You see that? That belongs to the city.
And why are you here?
Mr. Roberts tells the workers that he's on an easement and not on private property because the utility poles on the property belong to the city. While, according to Florence County's Geographic Information System, or GIS data, it does appear that Mr. Roberts is on public property, it is important to note that the fact that the government has placed utility poles on a certain property does not necessarily mean that the property is open to the public. For instance, in some circumstances, the government may obtain a so-called utility easement, which allows the government to place utility poles on private property without transforming the ownership or the otherwise private nature of the property. For this reason, contrary to this common misconception in the auditor community, the location of utility poles alone cannot be used as a reliable indicator that an individual is on public property.
So let me ask you a question. Does that give you the right to come up and grab my camera and almost break it?
People here?
Hey,
you assaulted me, buddy.
Call 911.
Call the sheriff's department.
Hey, call your husband.
Yeah, call your husband, fat boy.
Man, whoa, this guy's great.
Get in, Tubby. I'm out in public recording, and you come up and grab somebody, dude.
Who are you with?
I'm with myself.
Oh, you just
and you're about to owe me a new camera lens. Yeah, buddy, I got your name too. You're gonna get it. You're gonna get a nice little talking to with the police. You come back out here and touch me, you won't like it.
What's going on, bud?
Oh, nothing. Just getting assaulted out here. That's about it.
getting assaulted.
Yeah, by one of their workers.
What happened?
I was just out here taking some pictures, and one of the guys came out here saying he didn't want to be filmed, and he ran up to me, started circling me, grabbed my camera, started pushing up on me, and it's all videotaped.
You have it on video?
Oh, it's all recorded. Because I do want to press charges on him.
Was there something involving a tasing?
Oh, I pulled it out in self-defense.
Okay.
When you come out at me like that and you're about to destroy my stuff and do bodily harm to me, you're damn right I'm gonna pull a taser on someone.
Mr. Roberts argues that one of the workers assaulted him by grabbing his camera and pushing him, and that he pulled out his taser in self-defense in order to protect himself and his property. According to Section 16-3-600 of the South Carolina Code, quote, "A person commits the offense of assault and battery in the third degree if the person unlawfully injures another person, or offers or attempts to injure another person with the present ability to do so." As the Court of Appeals of South Carolina explained in the 2022 case of State versus Robinson, quote, "Our jurisprudence has never required an actual physical injury to a victim's person to constitute an assault and battery, and there's no requirement that a victim is, quote, physically harmed or violently injured." Likewise, the Fourth Circuit Court of Appeals, which has jurisdiction over South Carolina, summarized in the 2019 case of United States versus Drummond that, quote, "A violent injury for the purposes of an assault conviction requires no violence as commonly understood or a threat of physical harm or injury at all. Rather, an assault encompasses any touching of the person or an individual in a rude or angry manner without justification. Given this broad description of the type of touching that can constitute an assault, a court could easily conclude that the worker pushing Mr. Roberts was a sufficiently offensive form of physical touch for the worker to be convicted of third-degree assault. Additionally, under Section 16-11-510 of the South Carolina Code, quote, "It is unlawful for a person to willfully and maliciously injure or destroy any kind, class, article, or description of personal property or the goods and chattels of another." Under this statute, it is not enough to show that an individual damaged or destroyed the personal property of another. Instead, in order to sustain a conviction, the state must prove that the individual did so with a, quote, "willful and malicious mental state." As the Court of Appeals of South Carolina noted in the 2016 case of State versus Hobart, Black's Law Dictionary defines willful as, quote, "voluntary and intentional, but not necessarily malicious," and defines malicious as, quote, "substantially certain to cause injury," or, quote, "without just cause or excuse." Here, it could certainly be argued that the worker had the required mental state in grabbing Mr. Roberts' camera to justify a conviction under Section 16-11-510, although it's unclear from the footage whether the camera was actually damaged, and it clearly was not destroyed, as Mr. Roberts was able to continue to film the encounter.
You need to tell that guy he needs to not put hands on people. It's a short little fat guy.
I'm aggressive. Okay?
Oh yeah, we're gonna do a report on him too.
That's fine. I just need to give this deputy your information for me, all right? You have an ID or something?
I don't have an ID. Yeah, buddy, you're gonna learn you can't come outside and grab people, man. That ain't right.
While we're handling this, don't yell. You're just
All right.
cause him to get up.
Is it free speech? Am I allowed to say stuff?
Well, you have a freedom of speech, but there's also something called breach of peace.
Okay, I'd like to see you try that, buddy. Those people put hands on me. I'm the victim. So you want to turn it around on me?
I'm not turning it around.
Please do so.
What I'm telling you is...
You guys are known to be the biggest pieces of
okay.
in South Carolina. What did I do wrong?
Are you going to let me talk?
Go on ahead.
What I was saying is, I don't need you yelling while I'm trying to talk to this man, because that's going to cause him to yell, cause a scene. You get mad, he's gonna get mad, then it escalates.
Okay.
Just talk to this deputy.
Let me tell you something. I'm allowed to say whatever the hell I want.
If you yell across this parking lot while you have all these people standing around, that is called breach of peace.
You want to try that, buddy?
I will lock you up for
You
that,
want to
okay?
try that?
Yes, I will.
2 deputies with the Florence County Sheriff's Office responded to the worker's call, and while they're investigating the incident, one of them claims that if Mr. Roberts yells at the workers across the parking lot, he will be arrested for breach of peace. In South Carolina, breach of the peace is a common law crime, which means that it is defended by case law and not a statute. According to the Court of Appeals of South Carolina in the 1996 case of State versus Peer, quote, "The term breach of the peace is a generic one embracing a great variety of conduct destroying or menacing public order and tranquility. In general terms, it is a violation of public order, a disturbance of the public tranquility by any act or conduct inciting to violence." The court also explained that, quote, "Although it includes acts likely to produce violence in others, actual violence is not an element of breach of peace," and that, quote, "Whether conduct constitutes a breach of the peace depends on the time, place, and nearness of other persons." Similarly, Section 16-17-530 of the South Carolina Code, which defines the offense of disorderly conduct, states that, quote, "Any person who shall be found at any public place conducting himself in a disorderly or boisterous manner, or who, quote, uses obscene or profane language on any highway or at any public place or gathering or in hearing distance of any schoolhouse or church shall be deemed guilty of a misdemeanor." Although Mr. Roberts' conduct in yelling across the parking lot may appear on the surface to fall within the definition of breach of peace or disorderly conduct, as the Supreme Court held in the 1964 case of Henry versus City of Rock Hill, quote, "The 14th Amendment does not permit a state to make criminal the peaceful expression of unpopular views, and the government cannot define a criminal offense so as to permit conviction if an individual's speech, quote, stirred people to anger, invited public dispute, or brought about a condition of unrest." However, the Court of Appeals of South Carolina held in the 2002 case of City of Landrum versus Surratt that an individual could be convicted of disorderly conduct for loudly yelling profanities at 2 individuals and calling them names, because the remarks, along with with the loud manner in which they were spoken, constituted so-called fighting words. Under the fighting word doctrine outlined by the Supreme Court in the 1942 case of Chaplinsky versus New Hampshire, fighting words, or words that, quote, by their very utterance inflict injury or tend to incite an immediate breach of the peace, are not afforded the protection of the First Amendment, and therefore can be criminalized. Although Mr. Roberts did use profanity during his interaction with the workers and the deputies, he did not use any profanity when he shouted across the parking lot, and even if he had, it is highly unlikely that a court would conclude that Mr. Roberts' suggestion that the workers were going to learn that they can't lay hands on other individuals would incite an average person to violence. Therefore, a court would most likely determine that Mr. Roberts' conduct did not constitute a breach of the peace or disorderly conduct, as he was engaging in speech that was protected by the First Amendment.
Not going that
Try
route,
it. Try it. Name and badge number.
Corporal Triggers, 1-8.
Name and badge number.
Triggers, 236.
All right, go do my assault charge.
I need you to give him your information.
You need to go talk to them. And you better file charges if I'm giving you my information.
What's your day, bro?
If you don't, believe me, you guys will get complaints, and this will be all over you.
Whatever you need to do, man.
They have to run me first, everyone. They can't run the actual criminal. Can you go tell them, go question the guy who assaulted me?
He's gonna conduct his investigation. Do you see him up there?
No, he's not. He's inside hiding.
What was he wearing?
Yeah, a blue shirt. Short, dark hair, fat. So what was the call about?
Somebody coming up here harassing employees and pulling a taser on someone.
They tell you they circled me and surrounded me? The part where they assaulted me, they forgot, they left that out.
Well, Mr. Roberts, I spoke with the two gentlemen that came out, and all their information is going to be entered into the report as well as your statement you gave this deputy. I made them aware that yes, you can view video from a public area, which the roadway is public. But if you cross over into the
I've checked the property lines. I don't need directives.
you go on the property, you're going to go to jail.
If you smoke crack, that's not good, man. All right, do I get a report or something?
You're going to get you an hour.
Oh, great, this guy.
Here you go, buddy. All right, my name, badge number beside it, and your case number as well. You can get a copy of the report in 35 business days. Have a good day.
Thank you. See how the cop tried to spin it and say I was in their parking lot?
How you doing, sir? How you doing, sir?
Not too good.
Wow, what's going on today, buddy?
I had some dude inside. Oh, you're getting really close, man.
Oh, yeah, I like to get close. I like to talk to people.
Can you stop?
No, sir.
So
I want to talk to you. What's going on, my
stop,
friend?
Stop getting so close to me, dude.
What's going on, man?
Dude, stop approaching me.
Sir, I'm allowed.
Back off, dude.
Okay.
Give me some space, dude.
Go ahead and turn.
Give me some space,
Put your hands
dude.
behind your back.
No, give me some. Ow! Oh.
Behind your back.
What? For what?
Your piece.
For you?
Absolutely.
Oh yeah, very nice, dude. Very nice. Enjoy the lawsuit. Enjoy paying for my camera too.
Absolutely. You getting resisting arrest?
Resisting, I'm not moving.
Nope. When I went to put my hands on you, you pulled away from me.
Yeah, because you have no right to arrest me.
Sir,
I did
you're
nothing.
under arrest. You have the right to attorney
You
have
kept
him or present.
approaching me.
Sir, you have the right to attorney have him or present between questions and ask you to decide any time to exercise these rights and not make any more statement. Do you understand these rights?
I don't answer any more questions without a lawyer present.
Absolutely. All right, go ahead and stand them up.
Sergeant Paul Morrison responds to the scene and approaches Mr. Roberts, who asks him several times to not stand so close to him and tries to step away. When Mr. Roberts directs a profanity at him, Sergeant Morrison tackles Mr. Roberts to the ground and tells him he's under arrest for resisting because he pulled away from him. And Mr. Roberts argues that he did so because Sergeant Morrison had no right to arrest him. Under Section 16-9-320 of the South Carolina Code, quote, "It is unlawful for a person knowingly and willfully to resist an arrest being made by one whom the person knows or reasonably should know is a law enforcement officer. Although an individual can be convicted for non-violently resisting an arrest, if Sergeant Morrison was attempting to arrest Mr. Roberts, he never informed Mr. Roberts that was his intention or took any action that should have put Mr. Roberts on notice that he was under arrest. Therefore, a court would likely conclude that Mr. Roberts could not be convicted of knowingly and willfully resisting an arrest. Likewise, Sergeant Morrison had no lawful basis to arrest Mr. Roberts at the time he approached him, and it has been long established in South Carolina that individuals are not required to submit to unlawful arrests, and that individuals have the right to resist an unlawful arrest. The Supreme Court of South Carolina summarized prior case law on the subject in the 2001 case of State versus McGowan, explaining that, quote, "An unlawful arrest, or an attempt to make an unlawful arrest, stands upon the same same footing as any other non-felonious assault, or as a common assault and battery. The person who is so unlawfully arrested, or against whom such an unlawful attempt is directed, is not bound to yield and may resist force with force, but he is not authorized to go beyond the line of force proportioned to the character of the assault, or he in turn becomes a wrongdoer. It is important to keep in mind that this case law is specific to South Carolina, and many states do not recognize a citizen's right to resist an unlawful arrest. However, in this situation, Mr. Roberts would have a right to resist an unlawful arrest, and because he did not use any physical force at all by stepping away from Sergeant Morrison, there would be no question of disproportionate resistance if a court concluded that Mr. Roberts was resisting an unlawful arrest.
Joey can see again.
Got a taser, so.
Oh yeah, I already told him I got assaulted.
So here's the thing, you pulled it out and you was threatening him.
He attacked me. It's on camera.
All right. Well, we're going to log all this in too.
Good, do it.
After Sergeant Morrison placed Mr. Roberts under arrest, he was taken to jail and booked. However, it does not appear that any criminal charges were filed against Mr. Roberts, and after he was released, he filed a formal complaint with the Florence County Sheriff's Office. As a result of the complaint, the department opened an internal affairs investigation, and internal records indicate that Sergeant Morrison resigned on September 15, 2022. Sheriff T.J. Joy issued a press release about the incident, stating that, quote, "The internal affairs investigation determined numerous FCSO policy violations during the incident. As a result of the investigation, Sergeant Morrison is no longer employed by the Florence County Sheriff's Office." Sheriff Joy also noted that, quote, "The matter has been referred to the 12th Circuit Solicitor's Office, but as of the date of this episode, no criminal charges have been initiated against Sergeant Morrison." Additionally, Mr. Roberts alleged that after the incident, Sergeant Morrison deleted the video footage of the encounter from his camera. Fortunately, Mr. Roberts was able to recover the footage and post it to YouTube, along with a short video that appears to have been shot in the police cruiser after his arrest, which Mr. Roberts alleged Sergeant Morrison took while deleting the videos. The Florence County Sheriff's Office has not specifically addressed the issue of the deleted videos in any public statements. Overall, Sergeant Morrison gets an F for unlawfully arresting Mr. Roberts without probable cause, using unnecessary force in conducting the illegal arrest, and attempting to cover his tracks by deleting Mr. Roberts' video footage of the encounter. While Sergeant Morrison claimed that he was arresting Mr. Roberts for resisting arrest, he had no legitimate reason to arrest Mr. Roberts in the first place, and it seems clear that he actually arrested Mr. Roberts for refusing to submit to his arbitrary displays of overreaching authority. This type of police behavior is not only completely unacceptable, but it's also dangerous, and I commend the Florence County Sheriff's Office for swiftly investigating and dealing with this situation, although I do question the department's decision to allow Sergeant Morrison to resign rather than terminate him. The other Florence County deputies get a C, because although one threatened to arrest Mr. Roberts for breach of the peace in a situation that likely would not support such a conviction, they ultimately affirmed Mr. Roberts' right to film in public and educated the workers about his First Amendment rights. Although they appeared annoyed with Mr. Roberts and occasionally responded unprofessionally to his antagonistic remarks, they ultimately reached the right conclusion and supported his right to film. Mr. Roberts gets a B+, because although his aggressive and antagonistic behavior towards the workers and the officers alike certainly did not help the situation, and he demonstrated a misunderstanding about the nature of utility easements, he was well within his First Amendment rights throughout the encounter, and repeatedly stood up to the officers attempting to violate his First and Fourth Amendment rights. That being said, his mean-spirited comments about the workers' appearance were immature, and in my opinion, detracted from his credibility as a professional and respectable auditor.